record should reflect Dr. Nassar has arrived. Counsel?
As we are here today, before the court, we have a plea agreement that has been forwarded to the defense through the prosecution, and we are here today to effectuate that plea agreement.
All right, I need defense counsel and Dr. Nassar to approach the podium, please. Dr. Nassar, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you, and put your hand down. Sir, are you currently on probation or parole?
No.
Sir, I have you at an address contained in the felony information on Tiffany Lane. Is that your current address?
No, it's Nuevo.
Nuevo? Can you please give us that address?
1035 East James Street. What? 1035 East James Street, Nuevo, White Cloud, Michigan.
Give the zip code.
I don't, but I can do it for the court.
All right. And sir, are you a U.S. citizen?
Yes.
And you are or were a licensed medical physician?
I was.
Okay, you have since lost your medical license, is that correct?
I believe so, yes.
All right, thank you. Has a plea agreement been reached?
It has, Your Honor. Would the court like me to read the terms of that agreement?
Yes, I would, please.
Thank you. Judge, we have memorialized the plea agreement into an 8-page document that also includes 4 pages of an addendum. Does the court have a copy of it in front of her, or would you like me to approach that copy now?
I do have a copy of that. I received it yesterday and have read it, but we do need to make a record of that. Please.
Which I want to confirm that the court has the accurate copy. There was one minor change made overnight. I have additional copies if you would like that.
I do, my law clerk is indicating to me that the copy she placed on the bench is the current one.
Thank you for that. Judge, the people of the state of Michigan, through the Attorney General's office and the attorneys of the defendant, Lawrence Gerard Nassar, hereby agree to the following terms of the plea agreement. Paragraph 1, Defendant Lawrence Gerard Nassar agrees to plead guilty. The defendant shall plead guilty to 7 total counts of criminal sexual conduct, first degree, MCL 750-520B. Specifically, Defendant Nassar shall plead guilty to the following counts contained in the 5th amended felony information, which was filed with the court this morning. Count 1, criminal sexual conduct, first degree, victim under 13. This is for victim A. Count 2, criminal sexual conduct, first degree, victim under 13. This is for victim B. Count 5, criminal sexual conduct, first degree, multiple variables, victim C. Count 8, criminal sexual conduct, first degree, victim between the ages of 13 and 15. This is for victim D. Count 10, criminal sexual conduct, first degree, victim between the ages of 13 and 15. This is for victim E. Count 18, criminal sexual conduct, first degree, victim between the ages of 13 and 15. This is for victim G. And finally, the 7th count, count 24, criminal sexual conduct, first degree, victim under the age of 13, victim ZA. The second paragraph of our agreement reads as follows. This is an agreed upon minimum sentence range. The parties agreed to an indeterminate sentence with the minimum sentencing range between 25 years to 40 years for each of the above 7 counts. This court has final determination as to the minimum sentence imposed within that agreed upon sentence range for each count. Paragraph 3, maximum sentence range. The court also has the authority to determine the defendant's maximum sentence imposed for all 7 counts, so long as the minimum sentence is at most 2/3 the length of the maximum sentence. Paragraph 4, victim impact statements. The defendant agrees to allow all victims or their parent representative to give victim impact statements at defendant's sentencing hearing. Included shall be the 125 victims who have reported their assaults to Michigan State University Police Department and the other acts victims who've been identified on the People's Witness List. Paragraph 5, dismissal of remaining counts. In exchange for full compliance with the terms and conditions of this plea agreement, the people agreed to dismiss counts 3, 4, 6, 7, 20, 22, 25, and 26, and the reduced charges contained in counts 9, 11, 19, 21, and 23. I would note that counts 12 through 17 in the information have already been dismissed by the prosecution at the preliminary examination. Paragraph 6, non-prosecution agreement. The Michigan Department of Attorney General agrees not to further prosecute the defendant for all reported criminal sexual conduct charges reported to the Michigan State University Police Department as of November 22nd, 2017. We have attached Addendum A, which is a full list of identified cases reported to the Michigan State University Police Department, and of which the Attorney General is aware as well. There is a total of 115 cases. Further, the Michigan Department of Attorney General agrees not to prosecute the defendant for his possession of 4 images of child sexually abusive material recovered from defendant's electronic devices during recent forensic examination, and which are not part of his pending federal case. Paragraph 7, concurrent sentencing. Defendant Nassar currently faces charges in Eaton County Circuit Court. The people shall not object to concurrent sentencing for all 7 counts here in Eaton County and for any sentence imposed pursuant to the plea agreement in the case pending against the defendant in Eaton County Circuit Court. Paragraph 8, lifetime electronic monitoring and SORA. The defendant acknowledges and understands that he is subject to lifetime electronic monitoring pursuant to MCL 750.520N. The defendant also acknowledges and understands that he shall comply with all requirements of the Sex Offender Registration Act. It is my understanding the defendant, through his attorneys, will be making a factual basis, included which will be paragraph 16, but I'd like to place that on the record as well. Paragraph 16, waiver of defenses. Defendant Nassar waives any and all defenses he may have asserted at trial, including any defense that the conduct for which he pleads guilty was for a legitimate medical purpose. Paragraph 17, venue. The parties stipulate that the pled to crimes all occurred within Eaton County, Michigan. Paragraph 18, complete agreement. This agreement, along with a similar agreement in Eaton County, constitutes the complete understanding and agreement between the parties. No other promises have been made. Paragraph 19, subject to the approval of this court. The parties recognize that this plea agreement, as with felony guilty pleas, is subject to acceptance or rejection by the court. Judge, I'd like to make one other note on the record. Within the last week, the Michigan Department of Attorney General has contacted all 125 victims who have filed reports of abuse with the Michigan State University Police Department to discuss this plea agreement, to get their input to comply with the Crime Victims' Rights Act. We have done so both individually and through their civil attorneys, and all are in agreement with the plea agreement, and in fact, many are ecstatic and very relieved with this plea agreement.
Thank you.
Just for the record, I did get the zip code. Would you like that?
Yes.
It's 49349, and the correct address just to make sure you have it as 1035 East James Street. That's the Newaygo County Jail.
All right, well, technically, we don't live in the jail, but for this purpose, I guess that is appropriate.
Thank you.
All right, thank you. You've heard the agreement that's contained in the written document that it appears that you've all signed. Is that a fair and accurate statement on behalf of defendant?
It is, Your Honor.
Yes. Sir, is that your understanding?
Yes, Your Honor.
All right, and you've also signed this document?
Yes, Your Honor.
And you've had an opportunity to discuss all of this with your counsel, is that correct?
Yes, yes, Your Honor.
All right. Now, counsel, are you waiving reading of counts 3, 4, 6, 7, 20, 22, 25, 26, and 9, 11, 19, 21, and 23?
We are, Your Honor.
And then, of course, 12 and 17 were dismissed. All right. As to counts, 1, 2, 5, 8, 10, 18, and 24. You may proceed.
Thank you, Judge. As I indicated, we have filed the Fifth Amended information with the court, and it reads as follows. The people of the state of Michigan versus Lawrence Gerard Nassar. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, Bill Schuette, Attorney General for the state of Michigan, appears before the court and informs the court that on the date and at East Lansing, Holt, Michigan, and the date for the record is a range of July 1st, 1998 through April 27, 2015. We inform the court that the defendant in count 1 is charged with criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. The date is between August 2012 through October 2012 at an address of 4660 South Hagedorn, East Lansing, Michigan, and this is related to victim A. It is alleged that the defendant, being 17 years of age or older, did engage in sexual penetration, to wit, finger into genital opening with victim A, a child under 13 years of age, contrary to MCL 750.520B1A and MCL 750.520B2B. SORA notice, this is a Tier 3 offense under the Sex Offenders Registration Act, and that is pursuant to MCL 28.722W4. HIV STD testing notice, take notice that pursuant to MCL 333.5129, upon bind over to the Circuit Court or Recorder's Court, the District Court Judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV, if the judge determines there is reason to believe the violation involves sexual penetration or exposure to a bodily fluid of the defendant. If the district court determines that testing is not required upon conviction, the court must order the defendant to be tested. This is a felony and it carries with it a term of life or any term of years and a mandatory minimum of 25 years in lifetime electronic monitoring and mandatory AIDS STD testing. The defendant is charged in count 2 with the crime of criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. The date range for count 2 is March 2011 through May of 2011 at an address of 4660 South Hagedorn in the city of East Lansing, Michigan. This is related to victim B. It is alleged that the defendant, being 17 years of age or older, did engage in sexual penetration, to wit, finger into genital opening with victim B, a child under 13 years of age, contrary to MCL 750.520B1A and MCL 750.520B2B. SORA notice, This is a Tier 3 offense under the Sex Offender Registration Act, MCL 28.722W4. HIV STD testing notice. Take notice that pursuant to MCL 333.5129, upon bindover to Circuit Court or Recorder's Court, the District Court Judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involves sexual penetration or exposure to a bodily fluid of the defendant. If the district court determines that testing is not required upon conviction, the court must order the defendant to be tested. This is a felony that carries with it a possible penalty of life or any term of years, with a mandatory minimum of 25 years and lifetime electronic monitoring, mandatory AIDS or STD testing. For count 5, criminal sexual conduct first degree. This is pursuant to a relationship or multiple variable under the statute. The date range is February 1st, 2000 through April 30th of 2000. The location of the offense where it was committed was 2900 Hannah Boulevard in the city of East Lansing, Michigan. And this is related to victim C. It is alleged the defendant did engage in sexual penetration, to wit, finger into genital opening, with a child who was at least 13 but less than 16 years of age. And the defendant was in a position of authority over the victim and used this authority to coerce the victim to submit by exerting his authoritative position. This is contrary to MCL 750.520B1B. In the alternative, the defendant is charged, and it is alleged he did engage in sexual penetration, to wit, finger into genital opening with victim C, causing personal injury to said victim, and using force or coercion to accomplish sexual penetration, contrary to MCL 750.520B1F. SORA notice. This is a Tier 3 offense under the Sex Offender Registration Act, unless the court finds that the victim was between the ages of 13 to 15 inclusive, consented to the conduct, and the defendant was not more than 4 years older than the victim. This is contrary to, pursuant to MCL 28.722W4. HIV STD testing. Take notice that pursuant to MCL 333.5129, upon bindover to Circuit Court or Recorder's Court, the District Court Judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involved sexual penetration or exposure to a bodily fluid of the defendant. If the district judge determines the testing is not required, upon conviction, the court must order the defendant to be tested. Count 5 carries with it, it is a felony, a possible life offense that includes mandatory lifetime electronic monitoring, mandatory AIDS and STD testing, and DNA that is required to be taken upon the defendant's arrest. The court may impose consecutive sentencing under 750.520B3. Count 8, criminal sexual conduct first degree relationship with a date range of May 9th, 2014 through May 8th, 2015. Address involved 4660 Hagedorn in East Lansing, Michigan, and this is related to victim D. It is alleged the defendant did engage in sexual penetration, to wit, finger into genital opening, with a child who was at least 13 but less than 16 years of age, and the defendant was in a position of authority over the victim and used his authority to coerce the victim to submit by exerting his authoritative position. This is contrary to MCL 750.520B1B. SORA notice. This is a Tier 3 offense under the Sex Offender Registration Act, unless the court finds that the victim was between the ages of 13 to 15 inclusive, consented to the conduct, and the defendant was not more than 4 years older than the victim, pursuant to MCL 28722W4. HIV STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over to circuit court or recorder's court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involved sexual penetration or exposure to a body fluid of the defendant. If the district court determines that testing is not required upon conviction, the court must order the defendant to be tested. Count 8 is a felony offense that carries with it a possible life sentence, mandatory lifetime electronic monitoring, mandatory AIDS and STD testing, DNA to be taken upon arrest, and the court may impose a consecutive sentence under MCL 750.520B3. For count 10, criminal sexual conduct first degree relationship. The date is April 28th of 2012 through April 27th of 2015 at an address of 4660 Hagedorn in East Lansing, Michigan. And this count is related to victim E. It is alleged the defendant did engage in sexual penetration to wit, finger into genital opening with a child who was at least 13 but less than 16 years of age, and the defendant was in a position of authority over the victim and used his authority to coerce the victim to submit by exerting his authoritative position. This is contrary to MCL 750.520B1B. SORA notice. This is a Tier 3 offense under the Sex Offender Registration Act, unless the court finds that the victim was between the ages of 13 to 15, inclusive, consented to the conduct, and the defendant was not more than 4 years older than the victim, pursuant to MCL 28.722W4. HIV STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over the circuit court or recorder's court, the district court judge shall order the defendant to be tested for venereal diseases, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involved sexual penetration or exposure to a body fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. Count 10 carries with it is a felony, carries with it a possible life term, mandatory lifetime electronic monitoring, mandatory AIDS and STD testing. The defendant's DNA is to be taken upon his arrest, and the court may impose a consecutive sentence under MCL 750.520B3. For count 18, criminal sexual conduct first degree, again, multiple variables within the relationship. Date, range is April 26, 2008 through April 25th, 2011. The location is 2255 Tiffany Lane in the city of Holt, Michigan. This is related to victim G. The defendant is charged, and it is alleged he did engage in sexual penetration to wit, finger into genital opening with a child who was at least 13 but less than 16 years of age, and the defendant was in a position of authority over the victim and used his authority to coerce the victim to submit by exerting his authoritative position. This is contrary to MCL 750.520B1B. SORA notice. This is a Tier 3 offense under the Sex Offender Registration Act unless the court finds that the victim was between the age of 13 to 15 inclusive, that consented to the conduct, and the defendant was not more than 4 years older than the victim. HIV STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over to circuit court or recorder's court, The district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV, if the judge determines there is reason to believe the violation involved sexual penetration or exposure to a body fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. Count 18 is a felony. It carries with it a possible life sentence, mandatory lifetime electronic monitoring, mandatory AIDS and STD testing, DNA to be taken upon arrest, and the court may impose a consecutive sentence pursuant to MCL 750.520B3. Finally, Judge, for count 24, criminal sexual conduct, first degree, person under 13. The date range is July 1st, 1998 through January 18th of 2005. The location is 2255 Tiffany Lane in the city of Polk, Michigan, and this is related to victim ZA. The defendant is charged with, and it is alleged he did engage in sexual penetration, to wit, finger into genital opening with victim ZA, said person being under 13 years of age, contrary to MCL 750.520B1A. This is a Tier 3 offense under the Sex Offender Registration Act and pursuant to MCL 28.722W4. HIV STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over to Circuit Court or Recorder's Court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV, if the judge determines there is reason to believe the violation involved sexual penetration or exposure to a body fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. Count 24 with victim ZA carries with it a life or any term of years sentence, mandatory AIDS STD testing. These charges are brought against the defendant and are against the peace and dignity of the state of Michigan, and I have signed the information on behalf of the Attorney General's office. Thank you.
Thank you. Sir, did you understand what was just read?
Yes, Your Honor.
All right. So you understood that count 1, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older, victim A, is a felony, life or any term of years, mandatory minimum of 25 years, and lifetime electronic monitoring, mandatory AIDS, STD testing. Do you understand that?
Yes, Your Honor.
All right. And you understand count 2, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older, victim B, is a felony, life or any term of years, mandatory minimum of 25 years, and lifetime electronic monitoring, mandatory AIDS, STD testing.
Yes, Your Honor.
And count 5, you understand criminal sexual conduct, first degree, relationship, victim C, is a felony, life, mandatory lifetime electronic monitoring, mandatory AIDS, STD testing, DNA to be taken upon arrest. Was DNA taken already, sir?
For the most part.
I'm sorry?
Yes, Your Honor.
All right, thank you. And the court may impose a consecutive sentence per the statute. You understand that?
Yes, Your Honor.
All right. And you understand count 8, criminal sexual conduct, first degree, relationship, victim D, is a felony, life, mandatory lifetime electronic monitoring, mandatory AIDS, STD testing, DNA to be taken upon arrest. The court may impose a consecutive sentence per the statute. You understand that as well?
Yes, Your Honor.
And count 10, criminal sexual conduct, first degree, relationship, victim E, is a felony, life, mandatory lifetime electronic monitoring, mandatory AIDS, STD testing, DNA to be taken upon arrest, and the court may impose a consecutive sentence per the statute. You understand that as well?
Yes, Your Honor.
Count 18, criminal sexual conduct, first degree relationship, victim G. You understand that's a felony, life, mandatory, lifetime electronic monitoring, mandatory AIDS, STD testing, DNA to be taken upon arrest. The court may impose a consecutive sentence per the statute. You understand that as well?
Yes, Your Honor.
Finally, count 24, criminal sexual conduct, first degree, person under 13. That's a felony, that's victim ZA. Life or any term of years, mandatory AIDS, STD testing. You understand that?
Yes, Your Honor.
All right, thank you. Do we have the advice of rights form?
I do not.
You may approach. Thank you. Sir, I have the advice of rights form. It looks like you signed it today. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
If you had any questions, were your attorneys able to answer those questions in regard to your rights?
Yes, Your Honor.
Do you have any questions about your rights of this court?
No, Your Honor.
Sir, are you ready to plead at this time?
Yes, Your Honor.
As to count 1, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older, victim A. How do you plead?
Guilty as stated, Your Honor.
Count 2, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older, victim B. How do you plead?
Guilty.
Count 5, criminal sexual conduct, first degree, relationship, victim C. How do you plead?
Guilty.
Count 8, criminal sexual conduct, first degree, relationship, victim D. How do you plead?
Guilty.
Count 10, criminal sexual conduct, first degree, relationship, victim E. How do you plead?
Guilty.
Count 18, criminal sexual conduct, first degree, relationship, victim G. How do you plead?
Guilty.
Count 24, criminal sexual conduct, first degree, person under 13, victim ZA. How do you plead?
Guilty.
Sir, do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, it would be by application of leave to appeal, meaning you'd first have to ask permission of the Court of Appeals to appeal. They will look at the issues that you present. If they think that your issues are important, they'll grant you your request. If they decide your issues are not important, they will deny your request for appeal. Do you understand?
Yes, Your Honor.
Do you understand that by pleading, you are also giving up any claim the plea was the result of promises or threats not disclosed to me here today?
Yes, Your Honor.
Did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Other than the very extensive agreement that was placed on the record, did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Did anyone promise you anything other than this agreement to plead?
No, Your Honor.
And sir, do you understand that you're also giving up any claim that was not your own choice to plead guilty?
I'm sorry. Could you repeat that?
I know you're a little nervous. So, right now, unless you tell me otherwise, you're giving up any claim that was not your own choice to plead guilty.
Yes, that's correct.
So no one forced, threatened, or coerced you to plead.
Yes, that's correct.
You're doing this of your own accord.
Yes, that's correct.
Sir, have you taken any medication yesterday or today?
No, Your Honor.
All right. And you're feeling okay today? Other than a little nervous?
Under the circumstances, yes.
All right, thank you. Now, sir, do you understand that there's this recommendation as to how I should sentence? I do not have to do that. If there's in regard to the minimum sentence and the consecutive sentence, I can concurrent sentence, I can go above the minimum that's recommended. They've done what we call a kill group. However, if I go beyond that, if I go higher, I will allow you to withdraw your plea, and this would again go to the pretrial stage. Do you understand that?
Yes, Your Honor.
It is not often that I do that, but once in a while, after I hear from the victims, after I've read the pre-sentence investigation report, I think I ought to go and do something different, higher. I have that right to do that. But because you have pled based on this agreement that you all have made, which I'm not part of, I allow you to withdraw the plea. Do you understand that?
I believe so, Your Honor.
All right. So I just need to inform you of that, okay?
Yes, Your Honor.
All right. Other than the plea agreement, has anyone told you what I will do at sentencing?
No, no, Your Honor.
Okay. I don't know. I've not made any agreements with anybody. Do you understand that?
Yes, Your Honor.
And that's why you don't know, so that's a good thing.
Yes, Your Honor.
Okay. Now, I may have some questions, but at this time, I'm going to allow your attorneys to inquire of you in regard to the counts that you've pled to, okay?
Yes, Your Honor.
Now, I need you to keep your voice up. You can move the microphone closer, or you can just step closer to the podium a little bit.
Okay.
All right? We need to get a good record of this. That record is for you, all right?
Yes, Your Honor.
Okay, that's much better. All right.
Okay.
Okay. Okay, with respect to count one, victim A, between August 1st, 2012 and October 1st, 2012, did you sexually penetrate victim A by putting your finger into her vagina?
Yes.
And at that time, was victim A under the age of 13?
Yes.
With respect to count two, victim B, do you agree that between March 2011 and May 2011, that you sexually penetrated victim B by putting your finger into her vagina?
Yes.
And at that time, was victim B under the age of 13?
Yes.
With respect to count five, victim C, do you agree that between February 1st, 2000 and April 30th of 2000, that you sexually penetrated victim C by putting your finger into her vagina?
Yes.
At that time, was victim C between the age of 15 and 13?
Yes.
And do you acknowledge that as her doctor, you were in a position of authority over her and used your position of authority to constructively coerce her to submit to penetration?
Yes.
With respect to count 8, victim D, do you agree that between May 9th, 2014 and May 8th, 2015, you sexually penetrated victim D by putting your finger into her vagina?
Yes.
At that time, was victim D between the age of 13 and 15?
Yes.
Do you also acknowledge that as her doctor, you were in a position of authority over victim D and you used your position of authority to constructively coerce victim D to submit to the penetration?
Yes.
With respect to count 10, victim E, do you agree that between the dates of April 28th, 2012 and April 27th, 2015, that you sexually penetrated victim E by putting your finger into her vagina?
Yes.
Do you agree that victim E was between the age of 13 and 15 at that time?
Yes.
Do you acknowledge that as your doctor, you were in a position of authority over victim E and used your position of authority to constructively coerce victim E to submit to the penetration?
Yes.
With respect to count 18, victim G, do you agree that between the dates of April 26, 2008 and April 25, 2011, that you sexually penetrated victim D by putting your finger into her vagina?
Yes.
At that time, was victim G between the age of 13 and 15?
Yes.
And do you acknowledge that as her doctor, you were in a position of authority over victim G, and that you used that position of authority to constructively coerce victim G to submit to the penetration?
Yes.
With respect to count 24, victim ZA, do you agree that between the dates of July 1st, 1998 and January 18th, 2005, that you sexually penetrated victim ZA by putting your finger into her vagina?
Yes.
Do you agree that victim ZA at that time was under the age of 13?
Yes.
Do you understand that in the plea agreement and what we've put before this court today, you are waiving any defenses that your actions were for a legitimate medical purpose?
Yes.
And you have initialed each page of this plea agreement, is that correct?
Yes.
And you have signed your signature to the back of it.
Yes.
Do you have any questions for myself or Mr. Newberg before the court goes forward in accepting your plea?
I have no further questions.
Sir, in fact, what you did in touching these victims in all of these counts was ungloved. Is that correct?
Yes, Your Honor.
And it was not for any medical purpose. Is that correct?
What?
It was for your own purpose. Is that correct?
Yes.
And in fact, it was against medical protocol. Is that correct?
Yes.
On behalf of the people, any additional questions?
No, thank you, we're satisfied, Your Honor.
Any additional questions?
No, Your Honor, thank you.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
People are not, Your Honor.
There are none, Your Honor.
No, Your Honor.
And sir, I have one last question, and that is, these victims were all too young to consent, correct? And you knew that, both of those.
Yes, Your Honor.
Was a yes to both questions?
Yes, yes.
And you understood both questions?
Yes, Your Honor.
Does the court comply with the court rule?
It has, thank you.
Yes, Your Honor, thank you.
I find defendant's plea has been freely, voluntarily, and understandingly made without undue influence, threats, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, counts 1, 2, 5, 8, 10, 18, and 24 will enter. Counts 3, 4, 6, 7, 20, 22, 25, 26, 9, 11, 19, 21, 23 are hereby dismissed. Counts 12 through 17 were dismissed by the prosecution at the preliminary examination, so those technically don't need to be addressed. Further, the Michigan Department of Attorney General will be held to their agreement placed in Addendum A, and their further agreement not to prosecute defendant for his possession of 4 images of sexually abusive material against children recovered from defendant's electronic devices during recent forensic examinations, which are not part of the pending federal case. Sentencing will be January 12th at 9 a.m. This will be all day. Victims will be allowed to speak. And if we do not finish on the 12th, we will continue on Tuesday, the 19th. January 12th is a Friday. The 16th is a Tuesday because the 15th is a Monday, it's a holiday. And will continue until all victims have had an opportunity. You may speak verbally at the podium. You may present written statements that the Attorney General or I may read. You just indicate what you want done. You may do it also by video that we can play. Or if you are off-site, you can make arrangements. We do have the electronic equipment. If you do not wish to be in this courtroom, we do have a room down the hall that you can watch from for privacy reasons. I do know that some victims do not wish to be here. They want to watch. We're trying to accommodate everybody's needs. We just need to let the victim advocates know, and we will try to accommodate what the needs are. If you wish to state your name, you may. If you do not wish to state your name, you can use an initial and give me your name and I'll put it in my file so we know who you are for later purposes. Just talk to the victim advocate and we will try to accommodate you.
Your Honor, while I know this is an unusual request, may Dr. Nassar please make a statement at this time?
Yes, Dr. Nassar may make a statement, and the follow-up to that is that if there is a victim, any victim who wishes to make a statement now, who is not available at the time of sentencing, I will also allow that today. We do have the time this morning. I don't know if any victim is ready to speak today, but certainly we do have time this morning. So please let us know. Dr. Nassar, or Mr. Nassar, I think it's more appropriate. What would you like us to know?
I think this is important, that what I've done today to help move a community forward and away from the hurting, let the healing start. That's a couple of things that I could do to stop the hurting is this, and I think that's important. For all those involved, and that I'm so horribly sorry that this was like a match to turn into a forest fire out of control. And I pray the Lord here every day for forgiveness for I want them to heal. I want this community to heal. I have no animosity towards anyone. I just want healing this time. So I guess that's the biggest thing, is we need to move forward in a sense of growth and healing, and I pray that.
I appreciate that you recognize that. I think that what you'll hear from the victims, although I don't know, I don't speak for them, they have voices. I think it may take some of them years to find those voices, although the showing here today, I'm very proud of them for being here, for finding those voices. That tells me they're finding the strength to come here today to show you that they're not victims anymore. You used your position of trust. You used that position of trust that you had in the most vile way to abuse children. I agree that now is a time of healing, but it may take them a lifetime of healing while you spend your lifetime behind bars, thinking about what you did in taking away their childhood, which you were trained as a healer on what you did to harm them. You violated the oath that you took, which is to do no harm, and you harmed them selfishly. I'm not going to speak for them. They're going to have that opportunity at sentencing. And that will strengthen and heal them. I agree, and I'm glad you recognize that. But it does fall very short. but they are strong in numbers, and I'm proud of them. They are superheroes for all of America because this is an epidemic. That's all for the record. I will see you January 12th.
Thank you, Judge.
Judge, we have just a couple of other
Yeah.
issues.
Oh.
In light of your,
Let's go back on the record.
in light of your acknowledgement that there may be victims, may I inquire if there are any currently who are not?
Oh,
able
I'm
to
so
be-
sorry, because I did allow them, yes. I got wrapped up in all that, so let me just say, are there any victims who wish to talk today? I don't see any hands up. All right, let me just also say that the media is all hooked up here, and I know the media wishes to talk with counsel and perhaps some victims, if there are some victims who wish to address the media. Rather than going out in the hall, we do have security here. I'm gonna ask the media to stay here. If counsel wishes to talk to the media, please come forward, talk to the media. Victims, if you wish to make a statement to the media, please also come forward. I know the media wants to talk to you. They've got their cameras here, they've got their notepads. Please come forward, don't make them go out in the hallway. Stay here, they wanna talk to you, get your stories out. It's safer here than everybody roaming around the hallway. We've got security here. All right, anything else, counsel?
Theories, Judge, I'll defer to Ms. Liddell with regard to the gag orders that are in place.
Yes,
Oh, I'm sorry, yes, there was a motion.
that is correct, Your Honor. Just one additional issue as it pertains to the gag order. The people at this time are requesting this court to lift both gag orders, the one being, the order limiting public disclosure and the order limiting public disclosure for covered individuals.
Any objection?
No, Your Honor, we would stipulate to that request.
And we have
And-
presented orders to the court, Your Honor.
The court has reviewed those orders. They are appropriate at this time, given that Mr. Nassar has pled. The court has signed them, and they'll be entered with the clerk in a moment. So the gag orders are lifted, and you are all free to speak. There's no reason for them anymore. They're moved.
Thank you.
Thank you, Your Honor.
That's all for the record. Thank you.